Other form memoache memoa memoakwaba ebe channel yiso dwumadie wa wani tua sede bia ye ne moa ana edie na ede nkomo ana ewo ho ede asem ana aba enkomo ewo ho no ene se dada no a sede eye Sedinam Tamakloe court eja no Jaya court ja no ana sese akoba se adofo amanfo kasa lawyers said ye and the edikame kind lawyers kasa judges kasa ana Ghana for so kasa na ni nyina mu no na ye hwa amanfo kire se Sedinam Jaya ye ja no ye politically motivated enu nti na ma ye de jai Sedinam na enam say ye politically motivated nti na se NDC for Omo yesa omo be satisfy omo appointees na se obi ye boni no odwane kwa said ye tie bia wo ba ye be yi no NDC aba wo so a ye be gya no saa so na manfo ka sa ene na MPP nso ba said ye tie bia ye ankasa ye chairman untumi wono nso so ye be gya no na we ya kire no ana ye sha ase se ye hwehwe se ensam dodo sen ana AJ anasa Attorney General Dominic Ayine Akorotenga wejemu amanaka sensa oba ebetena akonya so se Attorney General emra MPP lusu ya yeyi Godfred Odame efiri hono na eno na yahwehwemu ane yahu se Attorney General afare nori prosequa ejai enipa ebeburu 70 enipa beburu 70 no ana ye pese ye bubo edin ni bi ede kirew ema ohun se ampa Attorney General waja wo munti se Sedinam Tamakloe se aban no aja no a we enye nwanwa se Attorney General watumi ejai enipa be 70 wo mu case wo Ghana court a ekoso a enes was so agya Sedinam Tamakloe ade na kire se eye nwanwa na yenhwe nipa ni bie de adi kan ye papa kwabnadofo ya papa kwabnadofo ni nipa maako serving bia yesi wo mu adi Ghana dwirim adi Ghana sika ankasa ye nua Dr. Opuni kwabnapuni wo mu atwa na semnim Steven kwabnapuni na sam no a cocoa board de no wo mo atwam wo mo si asam no eni nyina so bia Alhaji Dauda wono nso so ye disagrami housing case no housing no ma no Alhaji Dauda NDC national organizer wono ono nso so wono na MPP for so no modi ko gina court for sagrami case no NDC for ba ye wo mo atwam de atoso mienu leak tape bia eba ya wa wani tua ye papa ofori ampofo ye be hihye ye be kunkum ne ade na no so ba ye no ofosu ampofo case eno so wo mo atwamu ana wo be kai semre bi ye ankasa ye nua Oliver Bama ho ono susu ni case no wo mo koye demonstration democracy hub for koye demonstration ya chichi nipa bi no wo mo chichi wo mo about 53 persons ana chichi wo mo case ni nyina say Attorney General wasi woni akire biem efrise eni enyina so bia nene say ya jai Sedinam Tamakloe nwanwa odofo enye nwanwa yo yanko na yanko ti adofo a wo mo kasa yenua bi etise yankasa yeba Eugene osei tutu wono wo kasa anani abre den
okay
as at Friday no makan as at Thursday no makan 30 pages Friday me ba love for my breakdown no makan 48 pages amachi mi could do if you bear one ana me time kan kakra me da bear 1 hour bi na me da ban so but me who a summary by Professor Kwekwaza and I think that it makes perfect sense based on what I usually say to have read.
Okay,
that does not mean that lawyers you can give them two provisions of the Constitution. The interpretations will vary. So that is his interpretation, and that is an interpretation I usually say to agree, having read the judgment myself.
Okay.
I don't know what
yes.
So let me issue that caveat so that someone will not come and say that way, man, and I don't want to take credit for somebody's work. It's not my right. But Abraham Madam Sedinam Tamakloe, he was acquitted and discharged, and acquitted and discharged basically, she cannot be charged for the same offense.
Okay.
Yes, sir. If you be left a double jeopardy, yes, sir. It's the law of natural justice.
That's right.
You cannot trial the same person on the same charges twice. Into the court, say acquitted me
okay.
Say be a discharge, say be a there be charged in the defense and cobra. But to acquit and discharge me, you go so some viewer.
Okay.
I will explain why.
Okay.
Na two attorney once a man for blame Godfrey so be true statement me minimum way be blame way. I don't think me view say u blame mienu na eyeye. I was with document why me dream say. You see there be am jana me kase me say oral cases no. Oye attorney general deputy obetumi akasa ne okasa. But at the end of the day, the person to give the verdict, to weigh the evidence you presented and what the accused person has equally presented will be the court.
Okay.
Mamu example, me YouTube channel the critical analyst. And I can say Hanan Okaya Judge Ruli what kind letter no. Said in Qatar any problem on Kwabuchiri.
That's right.
That's what the judge said. What do you want Attorney General to do? What's Qatar? Nani it will go UK. The judge granted.
Judge Amanda Quine.
Enti no say wo bufu na ka say bia Attorney General Godfrey Dame and I say ayenia mimi you say to them again say far fetch.
Okay.
Because they will present a case. The case is for someone to decide. As a FM who to me. Say you never say come here to never but the decision in me ho. If you won't listen and blame say you Jama, I don't take that decision. Kuku say could take that decision.
Yes.
So the one who takes the final decision, in my view, should be the one you question.
That's it. And it's very important say Nippon a court system now.
Exactly.
And until you can say Abaya Jai Sedina.
Yes. But me blame one because none will be.
Okay.
You can unanimous
be. That's right.
Baby, I said, because I knew, because it's senior. And then make us a surprise and me
that be
me surprise and every man said in Tamakloe. Why can't I not pay crime to see a bit me, because I know stay of execution. I pick what I'm for really.
Yeah.
The battle at
sure.
It's in a drain there to be a say, ya drink, Mamma, another example. It's Dennis Miracle. You are no closer to Dennis Miracle than me, you but make us say prosecuting why. Because the then is called quarter. And when you be the brief fact of the case.
Sure.
Say the then is at the end 5.2. You could say 55. Deputy Attorney General Crasso, no more ban card a brosa. Mebois. By a quarter. And I'm pretum shirt here black. I'm pretum shirt here white. Yes, I'm pretum here rasta. Yes, I'm pretum here tuntum. A quarter. Brief fact of the case. The one you be one.
When you can't send me.
Yes. And when I me say, and I will say, and you buying me penny say way and a fact. No, exactly. And you can't prosecute to be and yes, then is could jail and answer so much could me you say to now the view that's what could jail and obey me could and I want to make into how we how there's no bearing on my life.
That's all.
But so who no crana court, I know the positives of it. When the matter goes to court, when I charge you also have opportunity to
defend yourself.
Evidence.
That's right.
But you see, Sedinam Tamakloe, when I was reflecting on it this dawn, I said, "Me yati OSP I say in the Kenofria Tamata."
Oh, okay.
But I me true to mama. Say metro. I said, "Me yati OSP taxes be an person who Kenofria. The bro so person use one tiasi a warm ram. Me yati I say. And let's not forget the wound to me trial.
Yeah.
When Judge Audrey Kokuvite said that won't to me no mercy, my memory example send me rain. One ama Henry Okumson Koye Galam say Debbie make us so inquire reclamation. Oh my Missika, Debbie. Also, Uncle Dia Kube so 10-15 years near Tikubeni at Tom Kubesi get me reclamation. It's Oma a reason.
Yeah.
But deducing from the reason in the view of the judge, the trial, it doesn't make sense. The Kayamon Sumabaso. Now let's go to Professor Azanse. And me I think the international for blame Yura Gov Dominic Ayen and I letter on the band. Sometimes I troll letter and so on careful. Tiasemo will say the attention of the Attorney General has been drawn to the decision of the Court of Appeal acquitting the former master. Now, okay, so your attention has been drawn. You don't say to two. A German should not be here. It is Okuku se Kuka because my attention has been drawn to her. But where you won't mean Casa because we are party to the case.
Yes.
It's I think so almost some phrasing of letter no a problematic.
Yeah, but when is some?
Yes, let's go to the substance of Sedinam Tamakloe.
Okay.
First, you knew about Tampa microfinance. I must look more mobesia 500,000.
Okay.
No, this kind of coin, no about Tampa for say interest na mo de to so no prosecution case na me bon to fa che. Ana say na so muntimi jom fam sika emra me. Ana kon prosecution de good free so no ko twen no bato na total. To mo de sika na ma no. Ana ba Tampa chairman say, "Madam, sika de ma head de me serew, me hia letter bi e kire say." Why den? Waji sika no. According to prosecution, omukobu no letter no obatampo for de wo ho iyoko de no ayra. But sa sika na Madam said that time on 5 occasions actually ta come obatampa say monfa interest ya den na sika waje. Odi in August so letter say we hear interest. That is one.
Okay.
The second case in here sensitization bi a twa abo 1.8 million 1.7 million dollars man no ekowie no 1.7 million cedis ekowie ase no na o ma spend 1.8 million cedis na 10 regions then 16 regions so we just about 3 regions Accra Brown half I think voter region ni aka o manye and also charge tell you sika no misappropriation unse ba we mu dia ye nka no TV and one bro for sophisticated misappropriation. And a second one is a Cantamanto fire victims on 579 million. What's happening to me? 800,000 Ghana cedis.
579,800.
800. They just talk market 2015. Siko fen come woman. Yes, who di sikano. Again, okoto cars because na ne no. Esusun ebu onso amfa public procurement authority unsa wo koto aban ade bia na so de ko PPA no muhwem e kroje bibia no se onso anya saade again let's grant be otutu man hu mobile phone bi okoto se mobile phone ni 50 cedis a oton 70 cedis saade ni nyina account nom de ye the court no this is basically what the court said on all the matters. Let me just summarize for you. Court on the case said charge sheet ni e de man no e defective. Now let me explain the charge sheet. Unse the court was basically saying say a charge na the boss says okay account be conspiracy to steal. What ingredients are you basing on to say that there was a conspiracy to steal? You can't conspiracy say many am pretuma na pretuma microphone e de koduma e benya bu sa Eugene oh okay me kura me hu say CCTV no mu dum ne be 10 nti ebo 10 na hyiamase woni emetumi you conspiracy me no wako nakrana
yakoye kanana
say charge sheet no na sa bone a Sedinam Tamakloe dia wo de money laundering to no so wo de stealing it to no so wo de causing financial loss to no so wo de willfully causing financial loss to no so akeka ni nyina bo mekoye 78 charges no e to masuma enyeyi charges ni defective again no hold this say eba burden of proof so what can send them koto bibi only authorization from public procurement authority the onus lies on the prosecution and the one making the allegation to prove say no new authority no and shift bad and then cause the name was say yes we new authority to one be authority and as a new authority so the burden of proof per the appeals court at all material times was on the prosecution to prove that she didn't have the authorization. Now yanko enema 7 na mebo man yanko ba bia so. The court found serious evidential proof about Tampa. The original acknowledgement letter was not produced. The document tendered was a copy obtained from about Tampa. No corresponding master copy was produced. Evidence, even though the reference number on the letter suggested that master should have retained a copy. Unso kwa bankra tema copy. Let it be our date ni be numbers bi no oba Tampa will let any bon call maslok no let any be ni ho now the of maslok official who testify has not seen an official maslok copy against which the document could be compared. The chairman of Obatapos who claimed that he had exchanged WhatsApp messages with Sedina concerning the refund, those messages were not produced. Obatapos oh me this can come said na bon komo ma me dia bo ska no kan aso Ka some for WhatsApp message mom de or want me and for message in your day. But let's not forget that at the appeals court, they will not sit over new evidence.
Okay.
They will not allow you to bring in new evidence.
That's
except
right.
in extremely exceptional case.
Right.
They were only assessing the facts as presented and ruled on at the lower court, which is the high court.
That's right.
It means a question I come one and say senior. The court when said now funny huni because they couldn't prove receipts. Because now Ogusu demand this kind of from about tamper, which means now on knees can in the view of the appeals court, yeah, 500,000 anyway.
Anyway, I will batampa and I say what he
said now. So I think that even though she's been acquitted and discharged, and the only route is going to a Supreme
there are still questions to be answered.
There are still questions, and maybe some civil matters must be considered in this matter. That is maybe view.
Sure.
Because there's no establishment of the whereabouts of the 500,000. And the 500,000 you crazy. 5 billion. And we come back 10 years ago.
And easy.
Senior, but what?
Sure.
TFN2. Now, the issue about sensitization. Tell us my children. Or say, the prosecution's case was that the program neither did not occur or occurred only on a very limited scale. The court held that the prosecution did not prove beyond reasonable doubt that Sedinam stole the money. The prosecution did not call the relevant regional officers or beneficiaries who could give direct evidence about whether the program took place or not. Instead, the trial judge expected Sedinam to prove that the funds had been properly used. The court held that this again wrongfully transferred the prosecution's burden to the accused. It's burden of proof now, or say, say. In case 10 regional chairman, from chairman, directors of master of operation water for musica buy program no na benefit on number one man fresh microphone would blame the man said in that Tamakloe. But you see, there's a phrase in here. Or say the prosecution did not prove beyond reasonable doubt. In criminal trial, you must prove beyond reasonable doubt. That's a sensitization.
So we
again, almost also can say countermand of market fire. No. Almost say one prosecution witness admitted that enquiries had established that the funds had been distributed to the victims. Another witness had confirmed this to him, although the information was omitted from the report tendered in evidence. The court held that this admission struck out the foundation of the stealing charge. If the funds had been distributed to the intended victim, the allegation of dishonest appropriation could not be sustained. The conviction and sentencing related to the countermand funds were therefore some say Stekanen could do a dance. Oh, you should share microphone be a tweet.
Stekamo.
It could do a dance as a tweet. This is Nipa no say yes car.
Neither they are saying
the same to be here. But the court also is not telling us. Yes, you can pay to some people.
Yes.
One prosecution
so who can
testify who were paid
that's
and
right.
how much they received. Now, make us say, unfortunately, at the appeals court, they are not at liberty
to do certain things. Yeah.
Now, I say, what happened to the money laundering conviction? Very important to say. They were set aside. The allegations stealing offenses were the underlining or predicate offense. Say, how do I explain? Supporting the money laundering members charges. In simple terms, the prosecution first had to prove that the money was the proceeds of an unlawful entity. Before someone can launder money or steal money, it must be from a certain unlawful act.
Yeah.
If that unlawful act is not proven, the person cannot launder or steal the money.
Okay.
And this is basically the summary. Court no boni nyina to go here. That's basically the summary.
Not just say you cast money. You cast money laundering. Now say it to me chima who say baby and dependence can free no. Enya kwampaso. Now when to me and chim say enya kwampaso a untimi kasa nipa no money laundering.
Why money laundering? And again no money laundering an element is be a sika na kwampaso. But the one who transfers can ni maybe a would ye ne baby a would fifa.
And so emfamra mu.
And to me fama kwaso no so money laundering. Good. Now court no ba cast no cast na mo cast Sedinam Tamakloe to ya mo charge no ho. MPP are buying the Kenufret and Bitu.
Okay.
They renegotiated and paid.
Okay.
It they all not sign contract. So that's also my issue. If you're saying that someone paid, the contract is a binding contract. They renegotiated and paid. But who signed the contract?
Signed it?
So I think that yes, she's been acquitted and discharged. That is the law. I'm not a lawyer.
Yeah.
But I think that commonsensically, they've raised some questions. In my view, and I think that you and I have debated on that matter. But let me skip. Attorney General so call Supreme Court Akosiki review of the matter. And now High Court transfer for the stay of execution. It means you need free prison. Yeah. I'm fat. Almost on conclave 2 hours on by decision to me. But the reason why I can't say I think that the blame on Godfrey Yabo Adame and Attorney General fair is that the case was handed over to Dominic Ayene. When they were defended, in fact, when you read the entire 43 pages, only time. When you read the entire 43 pages, he mostly argued the same point Godfrey Adame argued.
Okay, because the same fact, no, the
same fact. And in fact, what's here the body language of the Attorney General when he did the government accountability series? I know CRC report.
Yes.
Not 2 minutes.
Yes.
Look, I'll say, even the court in the US,
yes,
when they were presented with the evidence, believed in us and extradited Sedinam Tamakloe. So he is unhappy with the appeals court, and he had, in fact, I think that posture shows that he's very, very unhappy.
Sure.
Maybe that's my view. You entitled to disagree.
Sure.
But the reason I think it's not fair to blame them is something. You see, when they wrote, after the appeal came to the attention and everything, the Attorney General had to write. And senior, my kind court document, I think that that's one of the most strongly worded statements that Attorney General be.
That's right.
Standing by the fact,
decisions,
the conviction of a former Attorney General.
Okay.
It's me can't go for that response here be or see o ma me no na wo you me as obo kind Attorney General am na ma a bit uncomfortable kakra because I don't see where the Attorney General did the state wrong, and I'll read it for you.
Okay.
Because my country is chef and me view what the facts say.
Sir.
Now let's try there. Or say this is the Attorney General speaking. Already see preliminary objection. Whether it's the state attorney or whatever, they prosecute on behalf of the Attorney General. To get it is clear. Yeah. Even now, the OSP, you catch this one, it's
Attorney General
of the Attorney General. Okay. Now say, my laws, the antecedents to this case point to the fact that Sedinam, make appellant to Sedinam Tamakloe,
okay,
herein was tried and convicted in absentia. She was sentenced to 10 years, but remained a fugitive till because Sedinam Ghanaian, Mumubiza Montiasian, where Attorney General Neka say, remains a fugitive from justice, and as such has not served even a day of the sentence imposed on her by a court of competent jurisdiction.
Yeah.
Our criminal justice system has been marked by a persistent effort to balance the coercive power of the state with the fundamental rights of the individual. Or see, Ghana, yes, state no so. In Article 99, clear say, those say the state has unfettered access to power, resources, but when you be balance the human rights and the powers of the state. Yes, I did so. Mammy, I can't once a court, and my friend say, you try no.
Yeah.
Oh, Jane, 1 year cry, 10 years, and man on 7 years.
Yes.
Of course, however, a specific procedural dilemma arises when an accused person, having been duly notified of criminal proceedings, chooses to abscond.
That's right.
Attorney General say.
That's right.
Adiana mo be ye no. Muni hu say. Adiya ye be man no. Ya bon na man ye charge ye dia bonini.
Yes.
But we decided to be jane.
We jane. Proceedings crash I say for about 3 years.
That's Attorney General speaking.
That's right.
Leading to a trial and subsequent conviction in absentia. The legitimate question that arises is whether such an individual, now a fugitive from justice, retains the right to utilize the appellate machinery to challenge their conviction while remaining outside the reach of the law. I tell you now point and say,
that's right.
Legitimately the court eya wo de say obi a ono adwane from system na e pese punishing no system e born na mane say obone a wadi ni system na man ne kwan so ono so kan the side of so odwane ye no that's is it fair for that person to come back and use that system to vindicate a position. Okay. That's Attorney General speaking.
That's right.
It goes further to say that before we proceed to discuss the above raised issue, it is pertinent to put this appellant's case in a perspective and state the fugitive appellant is not challenging the procedural steps which were taken in commencing the trial in absentia as not meeting the legal threshold for proceedings in absentia. What she is challenging is the outcome of the said trial. It goes further to say that, my lords, it is right that the right to appeal in Ghana is a creature of statute underpinned by constitutional guarantees. It provides a mechanism for the correction of legal and factual errors made by lower courts. For a person convicted in absentia, understanding the statutory framework is the first step in determining whether an appeal can be mounted that is not just filed, but effectively pursued and heard by the appellate body. Into this page, the Attorney General basically goes to the Court Act of 1993, Act 459, to say that, appeal there, because the lower court they try from so To young from so there should be a bigger court who will sit on the matter, and it ends at the Supreme Court, where the appeal process will evaluate the facts and make sure that there is no error. And see, Sedinam Tamakloe appeal the Mramokraman the crime and more appeal no boss ankruna. Or say under the Court Act, the right to appeal is generally granted to any person who is aggrieved by a decision. This broad language suggests that the status of the person, that is whether they are in custody or fugitive, does not inherently extinguish the existence of the say send panejane. See a channel. Or which my appeal or build a point about the act provides that an appeal may be on a matter of law, a matter of fact, or a mix of law or fact. Say appeal there, law, ebi a mrano, continuity, ebi a fact no, when you ebi try a measure of the law and the fact. The appeal there will but your cousin or say. However, after establishing that some prechum court ne butiana, and mrama no hokwan.
So
at 459 to go to an appellate court. Or say, however, the Courts Act also grants the appellate court the power to regulate their own proceedings and to make orders that are necessary for the administration of justice. This includes the power to strike out appeals that are considered an abuse of the court process. This power granted the judiciary and the common law fugitive disentitlement doctrine put together means that once Act 459 grants a right to appeal, the court may refuse to exercise its jurisdiction if the appellant is in active defiance of the law. This creates a situation where the right exists in theory but may be procedurally bad in practice. Also, yes, Ghana manama how can say appeal, but who court now better appeal no so. If there's a defiance of law,
that's right.
You can use that to throw out the appeal.
That's right.
Because there's a defiance of law, and the judiciary must be the custodians and protector of the law.
That's right.
This is Godfred at the Dominican Attorney General speaking. It goes further to say that it is important to share light on the fugitive disentitlement doctrine at this point. That's what fugitive disentitlement doctrine or say the fugitive disentitlement doctrine is an equitable doctrine which prevents an evasive party from obtaining standing in the court which authority it evaded. Sorry. Or say okuku se kwa frame no one prechum se BBSC
me se me ma
ana ofre office Eugene bebo nkro me na mkobo wo charge am prechum mu nipa wona na ye kwa no ahye da dum microphone on madwuma ntam ne fact nye ana okuku fr ampre Eugene o kani obra me ma wo ye hwan me ma ana wa ma ana Attorney General ka se fugitive disentitlement doctrine ne say one man okuku se kwa bu echa se one man dey am suspend 1 year without pay e men sire fa bio afi na wo be ka se okuku no Eugene kan oboa ana Attorney General ka se sa de no ma ho kwan a enye yie o say
because
it's a doctrine which prevents an evasive the process evasive party from obtaining standing in a court which authority it evaded.
Your friend Renimu ama ye bo ebubo no dey o say me afẹ na me ba be defend me ho.
And Attorney General said yes sir
enye yi.
Now goes to say that it limits a person's ability to appeal as long as he or she remains a fugitive. According to the doctrine, an appellate court may dismiss an appeal when the person seeking the relief is a fugitive. It is important to state that Article 11 of the 1992 Constitution, the laws of Ghana, include the common law as well as the rules of law generally known as the doctrine of fact. Young Counsel Senator Kowama on his own appeal. She was arrested.
Yes.
And was citing authorities. Any other or citing authorities now no kind. But you see, to conclude for you why I believe the blame is not fair. The Hanokra the Yamakama and West Nan was Elfomu. Or cite authorities we no say. It is right that under our law, a convict who wishes to initiate an appeal must comply with specific procedural requirements, the most important of which is the filing of a notice of appeal. According to the rules, of course, a notice of appeal in a criminal case must typically be filed within 30 days of the date of the judgment or sentence. The act of filing a notice of appeal is a clerical or administrative task which notifies the court and the prosecution that the conviction is being challenged. At this stage, the physical presence of the appellant is not strictly required. A lawyer acting under instructions, even if the instructions were given before the client has gone, can technically sign and file the necessary paperwork. It must, however, be stated that the filing stated that filing the notice of the appeal is not synonymous with mounting the appeal. It is a submission that the latter involve the substantive hearing of the case, where the presence of an appellant becomes necessary, and as such a fugitive status possesses a significant value to the process. Sorry, it goes further to say that, my lord, the jurisdiction of the appeals court to hear an appeal, such as the instant case, is subject to several conditions precedent, some of which are found in statute and others in judicial policy. One of the primary limitations is the requirement that the appellant must not be in contempt of the very court system they are seeking to use. Or say, but one of the condition precedents is that the court you are coming under to vindicate your right, you must not be in contempt of that court.
That is I'm presuming
legal education. See now what I say?
That's right.
So that's Attorney General speaking. So how do you blame him? I don't see where you need to blame him. Now it goes further to say that one of the primary limitations is the requirement that the appellant must not be in contempt of the very court system they are seeking to use. It is our submission that the appellant who fled the jurisdiction during the trial and who has avoided serving the prison sentence imposed by a trial court could be viewed as being in the state of constructive contempt. And we urge this court to view her as such. She is in what? Constructive contempt. We further submit that the effrontery of the appellant to mount this appeal when she has conveniently decided not to surrender to the jurisdiction of the court is something that should not be countenanced by this honorable court, as the conduct of the appellant is an affront to the sanctity and integrity of the court.
No shit.
Also, Sedinam Tamakloe the new Wasamanka the effrontery kind of piece. Say court awobuna nimtia se nyakukuduro sa bad judicial system na wobuya nimtia no bepe reprieve. It goes further to say that it is trying that once a competent court of law issues an order, it is expected to be obeyed, except only when the order has been set aside. Now the concluding statement, for me, then I'll leave it to your judge.
Okay.
It is a submission that Cedis acting defiance of being at large is a flagrant disregard of the judgment and orders of the court that sentence, and as such, this honorable court should not entertain this appeal, as the conduct of the appellant is an affront to the administration of justice. This is appeal court. It may mean who will be person blame Godfred Dami and answer Dominic Ayene. At the end of the day, as I've always said when I do this analysis, it is a court who will decide.
And I think the court also will take it seriously, because we know Acquitted to say where's now Okano. I know she papa.
In fact, we know who. Who's our panelist number? We know you to form. It's a 43 page. I can forward it to you. If you read it in good conscience, I don't know how you blame either Godfred. In fact, in challenging the grounds of the appeal, the current Attorney General relied on all the facts of Godfred Dame. He relied on the fact. Okay. In fact, for me, these preliminary objections that they raise make common sense. Okay. That there's a process. Cameron also sit here. Yes. There's a process that called you that you have questions to answer. This is basically the fugitive disentitlement doctrine. Yes. You disrespected that process, and according to the Attorney General, he used fugitive. Yeah. He used abscond. He used fled. Not even serving a day until you are arrested. How do you come back to that same process to vindicate your position when you are, and in fact, the Attorney General said it here that she was duly notified of what? The charges. This is it. Or say, however, a specific procedural dilemma arises when an accused person, having been duly notified of criminal proceedings,
chooses to abscond, leading to a trial and subsequent conviction.
Exactly.
In absentia.
This is the Attorney General said, you were duly notified. So if indeed you knew these facts were not as it was being presented, why did you run? And that's the Attorney General speaking.
That's right.
So for me, I think that the greatest of respect, I have my issues with the court. But I always say that
that's right.
Some way, somehow, they are supposed to be the ones to do what?
It is in their bosom.
The matter. It is in their bosom.
That's right.
So how did? But me, you just said, you know what I was surprised about? It's the 3-0 decision.
Anyway, unanimous.
I was very surprised.
So
but for me, I think that what Attorney General done and the posture. It seems as if he's very, very upset by it. Because for him to quote,
yes, and US,
and you see, what is important for people not to know is that when Sedinam was extradited, the US statement was very instructive. Now, Jeff, I don't know, say, let me get it for you. Because you see, I tell you, say, one of the things my current lecturers will tell me that you need to do a content analysis of things, and it helps. I'm trying to get you what the court said, the US court said in the extradition of Sedinam Tamakloe. It was very, very important. So it tells you that it's not see Godfrey. The man for say, Godfrey, Dami anya juma ye. Godfrey, Dami anya juma ye. With the greatest of respect, the U.S. court, the same court I'm believing in. So U.S. is the cathedral of democracy. Yes. They say something there. I've sent it to Jeff. Jeff will project it. But I make kind from photos say, justice has no borders. The U.S. has extradited Sedinam Tamakloe to Ghana following a conviction on 70 plus corruption-related charges, including embezzlement more than $6 million, equivalent in Ghanaian taxpayers' funds. This is our strong U.S.-Ghana law enforcement partnership in action, demonstrating a shared commitment to accountability. And the first extradition from the U.S. to Ghana since 2009. In 17 years, a court in the U.S. saw evidence, and based on the weight of the evidence, decided that for the first time in 17 years, they will extradite this woman to Ghana.
Yes.
So based on all this, I say I'm surprised. This is why I'm surprised.
Okay.
But that is one. How many minutes more?
Okay. But NC 3-0. 3-0.
Okay. Now, the Attorney General press conference.
Ora for sweat me a share aba bedru sa amre ya ye be sese oba mbomode ansa oba subscribe amaye free subscription no eno so ehia nti yesra click so na subscribe maye na afi so share na like so emaye na Eugene ekasa wie ye no ananabi enso so ede ne de ebeto aso na nanabi a press conference in the name of MPP. Ana ochire mu say Cedis say Ghana court no system no aye no say Ghana judicial system na kwakwa to say they only side with the president and answer with the government. Enunti no ono de eka no nko a anka wo ka kire Ghana fo nyina say yemfa ye nan si fom na yenhwe say NDC fo nyadi a wo mu betumi ahihye wo mu ankasa mra na wo mu de agai wo mu apamfo name opposition for ni de ya chechi wo mu e de atum na enumu ana wo kire say ya saade a na kwakoye selective justice enu timumi yankotie na nabi so de ono so okaye.
Once again, good afternoon. Welcome to the headquarters of the New Patriotic Party. I stand before you this morning not merely to issue a statement or to have an interaction with you, but to sound an alarm. When the institutions charged with dispensing justice become instruments of injustice, silence is complicity. The New Patriotic Party will not be complicit. What we witnessed yesterday, the well-choreographed, well-planned, well-orchestrated acquittal and discharge of Madam Sedinam Tamakloe, who stole some 90 million Ghana cedis by the Court of Appeal. What we witnessed yesterday is not an isolated judicial outcome. No. It was the unmasking of a system, and this afternoon, we intend to expose this system and confront it squarely. Yesterday, Thursday, 30th July, the Court of Appeal acquitted and discharged Madam Sedinam Tamakloe Ationu, former Chief Executive Officer of Maslock, stripped away the judicial robes and the licensed phrases, and what remained is this: a woman convicted on the multiplicity of accounts of stealing, causing financial loss to the state, money laundering, breaches of our Public Procurement Act. And this lady was sentenced to 10 years imprisonment for plundering almost 19 million Ghana cedis belonging to the poorest Ghanaians, the market women, the farmers, the poor traders. These monies are meant for them. And yesterday, she was given her liberty, barely 7 weeks after the taxpayer funded her extradition from the United States of America. Consider this record, because the record is damning. This was a 5-year trial before a court of competent jurisdiction. 5 good years. The prosecution's case was built on documentary evidence, forensic audit, and sworn testimony. The convicting judgment of her ladyship, Justice Afia Sewa Asariboche, which we challenge every journalist, all of you here, we challenge you to go and read the judgment. It is very meticulous, count by count dissection of fraud, fictitious disbursement, monies meant for struggling market women dissipated. You remember the Kantamanto market? This woman dissipated monies meant for them. And above all, serious breaches of our public procurement laws. No serious lawyer or no serious Ghanaian who has read the judgment can honestly describe the evidence as seen, describe the evidence as anything other than overwhelming. She did not stay to answer it. She fled the jurisdiction mid-trial and was convicted in absentia. A fugitive from the very justice system that has now embraced her and freed her. And yet, within 7 weeks of her forced return, the conviction has evaporated. We ask the questions every Ghanaian is asking. On what principle of law does a mountain of evidence become a mirage? Which findings of fact were perverse? Which directions on the law were wrong? The Ghanaian people are entitled to answers because justice under our constitution is administered in the name, and they can smell what this is. This was not an appeal succeeding on its merit. This was an overcome, procured, packaged, and well delivered. The MPP states without fear of contradiction, this acquittal was politically motivated, well orchestrated and planned, and its timing on the eve of legal vacation, with public attention divided, is no coincidence. And it's not an accident at all. And we hear the Attorney General says he's going to go before the Supreme Court on appeal. It is all part of the well choreographed plan. Commencement of trial was 30th January 2019. Charge sheet was filed at the High Court Criminal Division. In all, 78 counts were filed. In all, 78 counts were filed. Among these offenses were stealing, conspiracy to commit crime, willfully causing financial loss to the state, conspiracy, improper payment of public funds, unauthorized commitment, resulting in financial obligations for government, breaches of our procurement law, on 24th, and this will blow your mind, Madam Sedinam Tamakloe advanced a loan to Obatampa Savings and Loans. It was a check, ADB check. The moment Obatampa Savings and Loans received this check, they asked of the interest. And this is even poor administration of Maslow. Why would Obatampa ask of an interest after the monies have already been advanced to them? And the interest was mentioned to be 4%. And they said, no, we cannot. Because we deal with farmers here, we deal with market women here, they cannot pay the 4%. And Madam Sedinam Tamakloe told the man to return the money. The man should cash the 500,000, cash, and bring it to Accra. The man obliged, cashed 500,000 Ghana cedis, met Madam Sedinam Tamakloe at Bachuna Total, packed the money in her car boot, and she departed. And she gave her a written consent that she has received the money. The monies were not lodged into Maslow accounts. Forensic audits revealed that the monies were never deposited in Maslow accounts. Yet we are being told that she did nothing wrong. Again, the board approved 1.6 million for her for sensitization and training program. She withdrew more than what the board approved. 1.816 million was withdrawn. Out of it, do you know how much she disbursed out of the 1.8 million? 1,300 Ghana cedis. The rest in her pocket. 1,300 Ghana cedis. Without compliance with the Public Procurement Act, she again signed a contract purchasing 350 vehicles. And it will surprise you. Let me go through it. I'll come back to the Kantamanto fire. Now, in 2016, without PPA's approval, she signed a contract for the supply of 350 vehicles, comprising 150 Avio Saloon, 100 Chevy Sparklights, and 133-seater Isuzu buses. On the Avio Saloon, she purchased one vehicle for $18,883, though the market price was $12,000. The market price was $12,000. Yet she alone bought it for $18,000. On the Chevy Sparklight, she bought one for $16,500. Again, the market price was $9,100. On the Isuzu 33 bar seater, she bought one for $112,000, 942. But the actual price was 74,493. In all, she pocketed $4.1 million, almost 50 million Ghana cedis. And the evidence is clear. These matters were investigated thoroughly. And yet we are being told that she should go home free with our money. In fact, at a point when a certain Samsung phone was on the market, selling on the market for 100 Ghana cedis, normal young phones, she alone bought it for 400 Ghana cedis. 400 Ghana cedis. You recall the Kantamanto fire, where 1.4 million Ghana cedis was meant for our market women. This woman pocketed 600,000 Ghana cedis. 600,000 Ghana cedis. At a point, she requested that she needed to seek medical attention. She never returned. 2021, 22, 23, 24, 25, and she returned 26. And in less than 2 months, she's been freed. Ladies and gentlemen, again, unapproved payment of 273,000. These monies again went to her. She paid herself and her deputy 135,000 Ghana cedis, 82,000 Ghana cedis, 28,000 Ghana cedis as gratia, unapproved. And she was meant to go through the judicial process fairly. She was never under any duress. And at the time, following her refusal to join the trial, on an application by the prosecution, the court on 24th, she left on 24th January 2023, ordered that her trial be held in absentia. She left in 2021. And the prosecution relaxed on their constitutional rule just because of fair trial. So 2021, she left. 22, she was not in the country. 23, that was when the prosecution put before the court an application for her to be tried in absentia. And again, to ensure that she was duly notified, the court further ordered that she be served by substitution in the following manner through her lawyers, Agbesi Jakwasu Esquire, her last known place of abode, publication in the national dailies and on the notice board of High Court for 21 days. After 21 days, she still failed to show up. Then trial proceeded in her absence accordingly. On 16th April 2024, judgment was delivered and she was sentenced to 10 years imprisonment. The trial judge in the judgment evaluated the evidence on record, including the cross-examination done by Sedinam Tamakloe's lawyers, her charge, and her caution statement. After the judgment, extradition request commenced under the 1931 extradition treaty with US. By July 2024, All the documentation from the AG's office had been completed and submitted to the US authorities. In August, US informed the AG's office that they had located her in the US. Her residential address was known and all her movement under surveillance. They placed her on the stop list. The US kept updating the AG until January 2025 when government changed. There was absolutely nothing left for government of Ghana to do. Every further step was left in the hands of the US government. Ladies and gentlemen, let me proceed by stating that it has become the modus operandi of this Attorney General. It was an agenda well conceived to free all their people. And I'm going to give you an account on that. Check this. The snitch scandal. Is it not worrying that the High Court in Accra also acquitted and discharged the former Director General and Board Chairman and two others who were accused of causing financial loss to the state to the tune of 70 million? Again, by just a stroke of pen. The Attorney General entered noli prosequi. And these are accused persons who were told to open their case. The court had ruled that you have a case to answer, so open your defense. Yet, the Attorney General, the current Attorney General, just went to court, entered noli prosequi, and acquitted and discharged all of them. The Unibank scandal. Again, we are talking about a whooping 5.7 billion Ghana cedis. It included the founder, Dr. Kwabena Duffuor, and many others. In fact, including even the current governor, Bank of Ghana. And again, the court had ruled that they have a case to answer. Yet, this Attorney General, because it is already a well-conceived agenda to free their people, again went to court with a stroke of a pen, entered noli prosequi, and freed all of them. We are talking about 5.7 billion Ghana cedis here. The Segleme scandal. Honorable Collins Downder and others. The monies involved, they were supposed to build affordable houses. And the monies were squandered. And they were standing trial for $200 million, the monies involved. And yet, the court had ruled that they have a case to answer. They must open their defense. Just when Attorney General, that was possibly the first set of assignment he was given. He again went to court, entered noli prosequi, and the court acquitted and discharged them. Huge monies. Then the Cocoa Board scandal. Again, we are talking about 271 million Ghana cedis involved in this. And the Attorney General freed them. Attorney General freed them. These are all monies. These are all financial loss to the state. So we are not surprised that from day one, they had already conceived that we are going to free Madam Sedinam Tamakloe. And it is worrying how the Court of Appeal would say. And I have this here, I'll read it out to you. In one of the rationale behind the judgment, Court of Appeal is saying the charge sheet was defective. How can the charge sheet be defective? How? When they never raised this matter during trial, it never came up. Even so, Section 4061 of Act 30 is quite clear, and I'll read it to you. Subject to the provisions therein after contained, no findings, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered on appeal or review on account of any error, omission, irregularity in the complaint, summons, warrant, charge, proclamation, order, judgment, or other proceedings before or during the trial. And this is quite clear. So you cannot base, even though it is true, assuming without admitting, yes, that there were some errors on the charge sheet, which was never raised during trial. The judges at the High Court, at the Court of Appeal, did a great disservice to Ghanaians. Great disservice. We are talking about 90 million Ghana cedis. And we can just hinge her freedom on the fact that there were some technical errors or errors, even assuming without admitting. So if there were some problems with the charge sheet, it means the person should run away with 90 million, when indeed Section 406 is saying that, look, even if you have some errors or irregularities on the charge sheet, that cannot free. You cannot reverse a court of competent jurisdiction, the decision based on errors or defects. Ladies and gentlemen, it is a wholesale amnesty for the politically connected, dressed up in prosecutorial discretion. But discretion under our law is not a private weapon. Under Article 296, it commands that it must be exercised fairly, candidly, and without, or it must not be done capriciously. What fairness, what candor is there in a prosecutorial policy whose only consistent principle is that the party card of an accused, Sedinam Tamakloe, stood convicted, so the front door of a nollie prosequi was shut. Yesterday, the back door was open for her. The Attorney General did not protect the public purse. He presided over a ceremony of betrayal. And I'm surprised. The Attorney General put in a very weak and a relaxed defense before the Court of Appeal. I think that the judges at the Court of Appeal should have done better. They should not have relied on some of these things, especially when 90 million Ghana cedis is at stake. Because the Attorney General is part of the choreography. So they put in a very weak defense, very relaxed defense. In fact, it was even captured in the statement. Let me also read this one to you. It was captured in the written submission of the respondent in answer to the appellant's submission pursuant to leave granted by this honorable court. And I'll read just a small portion. We wish to bring to the attention of the honorable court that the record of appeal before the court is not complete. We state that all the exhibits tendered by the prosecution during trial does not form part of the record. The only documents found as part of the record are some of the documents which formed part of the disclosure done by the prosecution. So it was even revealed that the Attorney General put in a very weak, very relaxed, very ill defense. So obviously, as we have predicted all this while, the entire choreography was to release and free Madame Sedinam Tamakloe. And to our judiciary, we say this with heavy hearts, but steady voices. Every judge of the Superior Court swears to do justice. And Article 17 of the Constitution guarantees every person's equality before the law. Yet, the pattern now staring the nation in the face is the two-track system of justice. One track, swift, forgiving, and generous for friends of the government. Another, harsh, hurried, and merciless for the opponent. Selective justice. And I keep saying this. There is a certain fear hovering on the judiciary. From 1992, we have never, no government, no president, we have never ousted our Chief Justice before. Never. It is only under President Mahama who promised NDC members that he was going to sanitize the judiciary. And indeed, it was part of their plan to oust the former Chief Justice, Madame Tokono. So the message is clear that if the president has been able to put in a system to remove the Chief Justice, then who am I? So it looks like, it appears, and that is what I see. Because I have been in court where a whole judge, a circuit court judge, is celebrating Idi Amin, such a notorious tyrant, such a notorious dictator. The judge is celebrating Idi Amin in his ruling. In fact, in his ruling, he stated that although all of us are equal before the law, as stipulated by the Constitution, in practice, some are actually above the law. That is what he said in his ruling. And do you know where this judge is now? He has been promoted. He's at the High Court now. He was the same judge who again introduced Animal Farm in his judgment. Such poor judgment, which received several criticisms. That ruling was widely condemned. Yet, he has been promoted to the High Court. So now the impression is that the impression is, do the bidding of the sitting government and you receive promotion. So there is a certain fear hovering over the judiciary. And that is why we say democracy under siege, democracy under attack. A judiciary that convicts the opposition on thin evidence in record time, whilst government allies walk free against overwhelming evidence, is not administering justice. It is administering politics in judicial costume. Public confidence in the court is the only currency the judiciary possesses. And yesterday, the currency was devalued before the eyes of more than 33 million Ghanaians and the international community. The message this government sent to the world yesterday is chilling. In Ghana today, accountability is for the opponent and impunity is for friends. Steal for the party in power and the law will find you innocent. Oppose the party in power and the law will find you guilty. Ladies and gentlemen, yesterday's acquittal cannot be viewed in isolation. It is the latest chapter in a sustained assault on the pillars of our Fourth Republic. Overnight, the Mahama-led NDC government has succeeded in undermining almost every single index of good constitutional governance in Ghana. This is their record. The removal of former Chief Justice. Let it never be forgotten where this all began. The murky, opaque, the constitutionally suspect process by which Her Ladyship Chief Justice Gertrude Araba Isaba Saki Tokuno was suspended and ultimately removed from office. That removal, conducted behind closed doors and in defiance to every principle of due process, transparency, and natural justice, was not an isolated act. It was opening move, the very beginning of a deliberate agenda to decapite the judiciary, capture it, and destroy the last institutional safeguard of good governance in this country. Everything we have witnessed since flows from this originating sin. And I keep saying, eyes are watching the Chief Justice. My Lord Bafuboni, eyes are watching you because you are the greatest beneficiary of this suspension and removal of Chief Justice Tokuno. Eyes are watching you. Again, your wife is also another great beneficiary of President Mohammed's administration. She was appointed to be Director General Prisons under President Mahama. So eyes are watching you. If things are not going well, if justice is being skewed, the legitimate questions people will be asking in their minds will be, is it because, my Lord, you have benefited greatly? Eyes are watching. Questions are being asked. And these are legitimate issues. You are now the Chief Justice appointed by President Mahama after the suspension and removal of Chief Justice Tokuno. And again, Madame Bafuboni has also gotten an appointment as the overall boss, Ghana Prisons. So is it the case that you cannot speak true to power? Is it the case? These are questions people are asking. Is it the case that there is that fear hovering over the judiciary? Is it the case? Are your people administering justice in fear? These are troubling times for our democracy. Troubling times for our democracy. Interference with the judiciary. The independence of our courts, the last refuge of the citizen, has been systematically compromised, with judicial outcomes increasingly tracking the political interest of the governing party. A brazen display of selective justice. Persons affiliated to the NDC are freed, discharged and acquitted, while opponents of government are hounded, convicted, and jailed on the flimsiest of evidence. The concentration of all so-called Operation Recover or Loot cases before only 2 judges, Justice Achibonga and Justice Kokuvite, who between them handle every one of these politically charged prosecutions, and whose conduct on these trials has strongly undermined the effort of accused persons to defend themselves. Now, these 2 judges, they are supposed to handle all cases involving NPP element. All cases. And indeed, they have also been sanctioned. They have been given strict instructions not to go on vacation, because the courts are on legal vacation, but they have been told, hey, stay back and make sure you do all these cases. People are asking questions. Why only these 2 judges? Why? Why only these 2 judges?
Na omo kasa wie ye no ana ye hwe ya Joy FM so ye kɔ hɔ no mo ye behu se eye ye nua Blessed Soga woni eye Richard Ahiagba of NPP, Director of Communications, woni no ede asiani enya agro ene kasa no na ye jejeje wo ye kura be kasa wo mo ba beko na chese we ka no we yaka no we yaka na ni nyina mu no eye Blessed Soga epeso kire se NPP fo mo na mo anya ade na mo amom ho moden enu nti na ama ene Sedinam Tamakloe yeja no ana Ahiagba se ehene ha rich Blessed men kasa na nya no kure eye NDC fo fragadam ana ama ene Sedinam Tamakloe yeja no yenko nkotie eye Blessed Soga ene Richard Ahiagba omo interactions no na afi no so yemfa de toaso embra
that has made waves and has dominated news headlines all throughout the day regarding the acquittal of Sedinam Tamakloe, the former Maslock CEO. My name is Blaise Ogan. You're watching Upfront, and there is a new development on the matter with the opposition New Patriotic Party now wading into that latest decision by the Court of Appeal, indicating that the former Maslock boss may no longer be incarcerated based on a number of reasons. The New Patriotic Party releasing a statement a while ago on the matter. Let's get right into it and tell you about what the main opposition party has to say about this latest development. You should have that statement on your screens now, pointing to the statement coming through from the NPP on the acquittal and discharge of Sedinam Tamakloe. A travesty of justice, the party calls it, asking for further evidence of what they say is now becoming a politicized system. I'll take you to the main demands the New Patriotic Party is making after learning with utter shock and dismay, they call it, of this latest development. Let's take you to the demands coming through from the New Patriotic Party, because lots and lots of concerns have also been emerging from the general public regarding that. But the NPP believes that that should translate into some actionable moves by the Attorney General. And there's a need for us to examine that and take a look at the main demands. So there you have it on your screens, pointing out that according to the New Patriotic Party, the demands are as follows. That once, since it is now, quote, abundantly clear that the Attorney General and the machinery of justice and the administration have no intention whatsoever of protecting the public purse, the Attorney General should, as a matter of consistency, fairness, immediately discontinue and discharge all appointees of the previous New Patriotic Party administration currently standing trial. It cannot be the case that the law is a weapon against one side of the political divide and a shield for the other. Bernard Nchibosiako, Chairman Wontumi, who we've been speaking about all throughout the month, the Ashanti Regional Chairperson of the New Patriotic Party. According to the NPP here, a court must be immediately acquitted, discharged, his conviction and outrageous sentencing of 20 years imprisonment with hard labor, which was politicized and politically motivated and procured without sufficient evidence. A fact his lawyers have set out in more than 20 grounds of appeal, now pending before the Court of Appeal. They want that also to form the grounds for which to act now. Why is the NPP making this demand, particularly when it's got to do about a case regarding a former appointee who was sentenced under their own regime? Let's get into it. Sedinam Tamakloe on your screens there. She's now a freed woman, but the NPP, and equally its Director of Communications, Richard Ahiangba, who's here with us in studio, doesn't believe she should be a free woman. You have any problems with your own kinsman, I should call her, or kinswoman, if there's any word like that?
Yeah. Well, blessed, let's be very clear so that we don't personalize the issue. We have a problem with corruption that has a lot of consequences for all of us in terms of our development, the resource we need to prosecute development. So that's a matter, let's take it away from there. And it's been a pain point for me to talk about it because I have to talk about it, everybody has to talk about it.
So you feel it's relevant when I do identity politics with you?
No, so let's be clear.
You're Richard Ahiangba, she said Sedinam Tamakloe. I'm asking you a direct question.
That what? That what?
You don't want to have mercy on your own sister?
No, but this is not about her. It's not about me. It's about building a system that all of us can have confidence in, right? So that there is a certain standard that glues society together. And that standard is applied to you equally as it applies to me. But then it doesn't become, and I think that the statement put it very expertly well, that it's not a weapon against a few and then becomes a shield for others. It has to be a weapon that deters all of us, right? But when you personalize it or you appropriate it for the benefit of others and then you are using it as a weapon against others, I think that you are not building a society, you are disintegrating society. Because then what happens is that when the tables turn tomorrow, which it will, most probably in 2028 when it does, then you create incentive for other people to do that. Then what would you then be doing? You are breaking society, you are breaking confidence, and then people cannot plan their lives. And in fact, it has implication for investment. You understand? People have their money, want to come in, since that our legal system
do you believe that justice was
up for sale.
When Sedinam Tamakloe was sentenced back in your regime, was that justice done at the time she was sentenced in absentia?
Of course, I don't understand.
She was sentenced in absentia.
Yeah, so
did you believe in that ruling? No, I'm asking if you believed in the other ruling.
I am not a judge.
The High Court.
I'm not a judge. I was not in court. The judge. It was not a kangaroo. It was not a kangaroo court. It was a court. Her lawyers were there. So if you ask me that question,
do you have confidence in that ruling of the High Court?
But why should it be up to me? It was a court.
Yeah, but people disagree with
do you have confidence in Wuntumi's sentence? Should I ask you that question?
That's not my work to do, is it?
Is it my work? I'm not a judge.
Your party has a position.
But I'm just saying that.
You're saying there's a travesty of justice.
Hold on. All of us should have confidence in our judicial system. The judges are supposed to be independent. They look at the evidence and reach a certain conclusion. Okay? We can quibble about evidence and matters, but when hold on, no, you cannot answer the question straightforward. You want me to answer as if I have some.
Do you believe in the High Court ruling at the time it was given as justice done?
It is not about me believing in it.
Okay, what was the position of the MPP then?
It was not MPP.
Oh, okay.
She went
to
hold on. Okay.
Godfrey Dami, who was appointed by President Akufo.
But what should be his position? He is prosecuting corruption on your behalf.
I'm asking you then, he was Minister of Justice.
Yes.
Justice done.
But he was not a judge, was he? All the attendant
about the judge.
No, hold on. But it's the judge. It's a judgment.
Yes.
So why is it up to me?
He was happy about the outcome of the case.
Maybe you are mistaking me for the judge, but you can call the judge.
What I'm telling you is, I'm telling you is, you are now able to draw a conclusion as a political party that there's travesty of justice. That's what you told us.
Yeah. So okay. So now let's
you have an opinion on rulings of courts.
No. Okay. So just set the ruling one way for now, because you and I are not judges.
You don't want to go back and look at the High Court ruling?
No, we can look at it.
It's on the basis for which an appeal was made.
Just relax.
The evidence hasn't changed.
Relax.
Nothing. No facts have changed, and that's the process of appeal.
Yeah. So we are not making any progress. If you just allow me, I'll make the point that we can make progress.
No, but if you can answer my question.
But that question is a disruptive question.
The reason why you don't want to answer
that question for that question
that
because I am not a judge.
You're picking and choosing.
No, my subjective judgment on the ruling doesn't amount to much.
Do you disagree with this latest? Do you disagree with this latest ruling?
Where are we starting from?
Do you disagree?
You are jumping from issue.
I'm asking you.
Ground the conversation.
I'm leaving.
No, hold on. No. You can't leave it.
Okay, so I'm asking.
Ground the conversation.
Did you believe in the High Court ruling?
It is not about my belief.
Do you believe in the High Court, the Court of Appeal ruling now?
What does my belief add to the conversation?
Your party just released a statement indicating there's a travesty of justice.
No problem. So let's get to the conversation.
No, the conversation answer my question first, then you can speak to your statement.
You are not asking a question.
My question to you is, did you believe that justice was served, Sedinam Tamakloe, when the High Court decision was made?
But is that not what you're expecting in a judgment?
Is that what happened to you? Is that what you see the process to have been?
But what else should I...
So justice is not being served now at the Court of Appeal?
Where justice means what to you now? What is that? That she's freed is justice to you?
It's part of the justice process, isn't it? If you go to court, you have two outcomes.
Okay, so you see where you are standing. You are standing naked, okay? You are standing naked because really now the Attorney General disagrees with you, and you are saying that her acquittal, is justice. That's what you're saying. But Attorney General disagrees.
I'm saying that based on the judgment of the court. Excuse, with all respect to the Attorney General, I don't
reposition the conversation.
I don't care what the Attorney General thinks about it.
So let's
I'm sticking with the reality now. The reality is that someone has exhausted the judicial process. There's an outcome to it. I'm asking you if you believe in that now and what happened before.
Okay, so forget about what I think. Let's look at the issue, independent of the two of us. Okay. Right. The matter here is that an individual has been convicted. She ran away from justice on bail. She didn't show up. That is a dishonest conduct to begin with.
By whose standard?
Huh?
By whose standard?
But you have a bail, which is a testament that when you need me, I'll come.
Yes.
Okay? And then you bolt after that. It's a dishonest conduct. By everybody's standard. I gave you my word that I will show up when you need me, and I disappear. And I went to hide in America. And government is in power. Instead of taking me straight to jail, they let me go home and cool off. And she was cooling off at the house until public agitation.
You've seen her at home?
Constantly. But you don't let her go back there. You knew she was not in Sawam when she came. She was in her house for about some 2 weeks. And then there was pressure. And Felix Ofosukwachi, the minister for government communication, was talking down to us, saying that, oh, why is people asking this? And I mean, we don't understand. The arrogance, we can understand it. Yes. Okay, that period went by. And then she got to Nsawam. 2 days later, she's at the appeals court, acquitted and discharged. Don't you see a pattern?
And you're saying that's injustice?
There is, no, whether you can call it what you want. But
you released a statement.
I'm not interested.
Your party didn't...
You want to pigeonhole the conversation. I want to give you evidence.
You can position of the political party on this.
Let your viewers reach a certain conclusion. I want to paint a picture for your viewers. This is an individual who bolted. Won't come to Ghana until her government came to office. She's come back to the country. Her government is protecting her. She won't go to jail immediately. She was sitting at home for 2 weeks. Then reluctantly, they sent her to Nsawam. 2 days after that, not literally, but a few days after that, she's brought back to appeals court, acquitted and discharged. Don't you see a pattern? If you don't see a pattern, let me go back and tell you. They come into government, all their people on trial, they issue a nolle prosequi, free all of them, okay? They are above the law. They are creating a certain class of people who are NDC people above the law.
Okay, can I concede
now everybody else should be equal to the law. Now you have juxtaposed that with what is happening with Wuntu, which is why the statement is calling for clearing all those people, because then we don't have a judicial...
As for that demand, Richard, I'll take you on that demand.
Yes.
But let's do this first. You've painted your picture, correct?
Yes, so a pattern has emerged that ours is now an animal farm where some are more equal than others.
Okay.
And is that something you like? Is that what you want?
Obviously not. Today I'm conceding with you on that point.
Okay, so but because you have to, because you don't have a choice.
Can I add to your point?
Yes, go ahead.
Do you recognize that your Attorney General at the time, appointed by your presidential candidate, i.e. then President Akufo-Addo, did a poor job and failed this country by failing the basics.
I'm listening to you. What's that? We haven't said anything.
Richard, that's in the judgment. The reason for which the lady is being acquitted and discharged now.
What is that? What is in the judgment?
The charge sheet for which Sedinam Tamakloe was being prosecuted was defective.
Defective how? And the lawyers argue that. The lawyers argue that in court.
That's the judgment. I wish I had the document.
No, but you don't have to have it. But I'm talking about
concluding to say that the reason for which no one for now is succeeding at still keeping her incarcerated is document for you. This is the judgment of.
Listen to me. My head is spinning at you telling me that.
Who was the prosecutor?
Listen. Let me ask you a few questions. You see, my head is spinning. You're telling me this, and it's as if you are indulging.
No, but I'm conceding your point and adding a bit more to it.
You see, here's the point.
Yes.
The monies that have been talked about. Where is the money?
No, you're talking about money.
I'm coming. Hold on. Please. I'm not interested in what the conversation you're having.
The prosecution
failed
because you can't put something on nothing. That's basically the point.
I don't understand what you're saying. You see,
Richard, I'm quoting from the judge.
I don't see. I haven't read it, but you tell me.
It's a 94-page document.
I can't believe what you're quoting.
I wish I could.
Yes, but if you don't have it, why do you bring it for conversation? I haven't seen it.
I've read that.
But I'm inviting you to reason about the matter.
You don't want to see
No, forget about the technicalities that they are going to use to free somebody. But I'm telling you, I'm inviting you to have a conversation about what it is we want to fight.
Yes.
We want to fight corruption. Okay?
Yes.
Somebody's dissipated state resources. We don't have the monies in question.
For now, you don't have the legal grounding to say she did that.
But the person has been convicted on that.
She's freed now.
Free on what grounds?
All other findings of any other inferior court would not hold now.
You know, when we are having these conversations, let's be mindful that what conversation we are having today has implication for our posterity.
That's what you keep doing at the NPP. The future is pregnant. You keep...
No, I didn't say future is pregnant. I'm telling you that... No, I'm saying that I didn't say it's pregnant. Pregnant means that
there's a lot going to
happen. I'm just telling you that it has direct implication for our posterity because we are holding this country.
The future is pregnant.
I don't know what language that is. I don't speak that one. But I'm telling you that tomorrow depends on the decisions we take today. And we are talking about fighting corruption. And an individual has been found guilty of a certain act of corruption. And you are telling me that a charge sheet is defective, and is defective on account of the fact that she didn't squander those monies? Is that the defect?
We're not going into that anymore. Because I've been issued the same justice. Procedure matters in delivering justice.
I don't know.
That's what the court is saying.
I don't know what your motivation is for lingering on this matter about.
You feel it's irrelevant? If you are being charged now, Richard, because you were with the NPP as well administration, if the NDC picks you up now and takes you through an illegal procedure of conviction.
What is illegal about charge sheet being defective? If the charge sheet is defective, it means it's illegal?
If there's something substantial that is missing in the charges, obviously there's nothing to accuse.
No, let's understand the language properly. Unless you have the statement here, what we're doing.
I have the ruling.
Well, you shouldn't have to introduce it if you don't have it.
I have read that. I have that on my phone.
Well, I don't have that.
Minutes ago.
I don't have that. But the point is that, let's even come here. Let's have her come here.
Yes.
Forget about a charge sheet being defective. Whatever that is, you are talking about some technicalities to do with that. It is not evidence to suggest that the monies that were said to have been squandered was not squandered. That's not what you're saying. You're saying that some technical law courtroom matter is the reason why monies that were lost to the state should be let go because some defect has been seen on the paper.
Yes.
Would you do that if you run a business and they say, well, so some defect in English, in writing something, and so therefore the money lost to your company is gone for good and the person is to take it? I mean, I don't understand what logic.
It's a party that prides itself as believers in the rule of law. You believe equally, I'm sure.
Defective, hold on. Charge sheet is not necessarily...
it's tied to the justice system. Because, and let me illustrate.
I don't know. Let me
illustrate that to you. Under Article 19 of our
Constitution. Say that particular thing. Let's engage it. What exactly is the defect?
What
is the defect?
Well,
What is the defect?
I was just going to illustrate that to you.
I mean, no, I don't need illustration because now I see where you are coming from.
No, it's not.
But I'm just saying that.
I'm not making that up.
I'm not saying.
Point is,
so read it to me. Until
matters.
that,
you cannot under criminal jurisdiction. You cannot charge someone for a crime that does not exist. So if your charge is defective, but that is grounded in law, Richard.
Now, I haven't seen that. But you know what we're talking about here. You know what happened?
Hold on. Buy me some time. I'll get that for you.
You know what you just said.
Yes.
What you just said.
Yes.
Listen.
Yes.
That is provided for in Article 1911.
Yes, precisely.
Okay. Right.
Your party believes in that.
But hold on.
Yes.
Right.
Yeah.
Just yesterday, when Wontumi was being tried.
Let me just.
Hey, lawyer, I'm coming.
Back to you because you are doubting me. This is the concluding part of the judgment, and it says, quote, and if you doubt me, we can refer to the document later on.
Which document? The appeals court's ruling?
Yes, ruling.
Okay, go ahead.
Just it came some few minutes.
No problem. So what is it?
Yeah. So I just wanted to read that to you. Oh my goodness, I'm just okay.
You don't have anything to read.
No, listen. Quote, a sentence is not an autonomous judicial order. It is a penal consequence of a valid conviction. Where the conviction is set aside, the sentence is deprived of its legal bedrock. That is the analytical framework within.
Oh my goodness! When people this here, and I want to say this. Let me say this, as a citizen who is interested. I want to tell you that you see my outlook in all that I do in this political space. I serve my party, but I believe in the cause of my party to serve the interest of this country. So my engagement is about Ghana, essentially. And so this one grant me the opportunity to tell you, and you believe me, that I am not talking as an MPP person. What you
now you don't want to belong to your party?
Listen to the premise I've created for you.
You are speaking as a Ghanaian, an objective Ghanaian.
You understand?
Yes.
What you just read for me there is the problem. The court is allowing itself to become an enabler of corruption.
How so?
What you are talking to me there is a court bringing some technical matter to tell us. But the point is that I'm asking you a fundamental question. The fundamental question is that where are our monies?
Which money?
The monies that she was said
and
to
who's
have
answering
dissipated.
For that, by the way?
She ought to be. And I'm telling you that right now, as we're saying, that effort that you just read is part of the grand effort to free her.
Richard, let's do this.
And
then, if I ask you,
the Attorney General disagrees with you anyway, right? Even though I see,
and I'm telling you, I don't have to side
the Attorney General,
the Attorney General, Minister for Justice.
Hold on. The Attorney General, our position is that this thing should not have a reason to begin with.
Yes.
But now it has a reason.
Yes.
The Attorney General's intervention with the appeal or opposition to the ruling is, for me, I see as a rules part of the grand effort, but disagrees with the opposition.
With me,
necessarily.
It's fine.
So I'm saying that let's give it occasion to go through.
And
but the point we are saying, and why you are getting into all these weeds about what they have said,
you feel
is
it doesn't matter?
I'm saying that
let me ask
when somebody has committed a crime, that the person has been sentenced, and knowing the pattern that has been created in this government, you can tell that where they cannot find nolle prosequi to clear the person off, they would go and find some clauses like this to free the person. That is part of the grand design. So why you are falling for it, I don't understand. Because that's your resource that's been dissipated. Okay, all the people who ought to have benefited from that money have lost the occasion. So we are talking about deterring people from dissipating state resources, and you are busy trying to quote something you are looking almost with a goggle to find and read to me.
But it's in the concluding part of the document.
My goodness. Let's get serious for once.
This is a 94-page
government
document. You should credit me.
It doesn't matter the number.
Level of diligence in trying to fish that out for you.
Well, I should credit you with a certain understanding that you are not focusing on the substance.
On the real matter. Okay,
you are focusing on the peripheral matters because you went looking with a microscope to find that one.
It's very important.
But that's not the substance of the matter. The substance of the matter is that we are fighting corruption, and this is freeing people from corruption.
That's exactly what your Attorney General and our Attorney General at the time, Godfrey Dami, did not do, paying attention.
No, you can't bring that here to have a conversation.
Okay.
She was properly convicted, okay?
Yes.
And I understand that this appeal process that has come to fruition, she was filed during our time. But the question you want to ask, if indeed it was filed during our time, why was no effort made to move it in the court at the time?
Whatever the case,
because now, listen, because now, you see, you look at the pattern I'm talking about, because now her government has come, NDC had come, and they are doing all the shenanigans to free her.
They are well within the prescribed time.
I find it difficult that you don't want to see
notice of appeal. They've done that.
Which notice of appeal?
They filed that way before now.
Yes. So the question is that.
Yes.
The question is that. Why did they not act on it?
That's not my problem. I'm not lawyer for Sedinam.
But whatever you are reading there, you are advocating for her. But I'm telling you that.
Is it fair now to ask? Can I proceed?
Listen. Wait. So you say you are not lawyers for her, and I'm telling you the reason they didn't do that because they knew they didn't have any case to appeal. But now their government had come, so they went to look for some clause in 94-page document that they dissipate state resource. You are looking for me for a line to say that on that basis she goes free. How do you fight corruption if that's what you are doing? How do you fight corruption?
No, to be fair,
how do you fight corruption? When if you are looking for a line in a 94-page document to free somebody?
To be fair,
are you serious about it?
Richard, no, that's not what I did.
I am shocked.
It's a whole gamut of issues.
I don't want to hear you for the rest of time for you to complain about corruption. If this is what you are going to be doing, using microscope to find one line in a 94-page document to say that somebody should go free.
I just wanted to.
I don't want to hear you say
the summary of the point. That's in the concluding part of the.
Please stop it.
Because the court effectively distinguishes,
let's get serious about this matter. We cannot be playing with these things.
If you're trivializing procedure, let me ask you this question: where is our money, and where is Kenneth Ofori-Atta keeping our monies?
Look at the movement from a matter before us to Kenneth Ofori-Atta.
So you believe that Kenneth Ofori-Atta has not been charged, right?
No, listen. Kenneth Ofori-Atta.
Procedure matters. So no one can go and ask him now where our money is, because as of now, it's not being charged. Correct?
What is your motivation?
No, I'm asking you the same principle.
Are we having a conversation for the public good, or we're having a conversation for blessed good, or are you in any?
I don't work for the court. No, I don't.
But are you a spokesperson for Madam Sedinam? Because what you are doing is to dig out some what's called a contrived line in a 94.
Contrived, yes. You're impugning on my integrity. That's
I'm not impugning. I'm just saying.
I mean, it's not fair, Richard, when you do that.
No, I'm not impugning your integrity. I'm saying you found it, and I'm saying that what you found is part of a grand effort to free her.
Where's Kenneth Ofori-Atta keeping our monies? Is it fair to ask you that question?
I am not a court. I don't have the power.
So yes, the court has decided on someone.
No, I'm saying that
she's free. She never even has any charges to answer to in the first place because it was defective.
And I am telling you, I have told you a pattern of this government.
Your same principle,
no,
Richard.
My principle is absolute, and I believe in.
So can we go then and ask Kenneth Ofori-Atta where our monies are?
I mean, I'm not holding Kenneth Ofori-Atta hostage in my house.
Yes. So why is he in the U.S. then? Same thing, same place.
Well, you should ask Sedinam why she was in the U.S. Ask her.
So same principle.
Well, how did she come back?
So if you have a problem,
how did she come back? Listen, how did Sedinam come back?
She was extradited.
Yes.
Yes.
So who did it? The state.
Is it fair to conclude that?
I'm saying that who did it? Follow the question. I don't know. What
said Sedinam had run away. That was your conclusion.
Yeah, of course. She left.
Same thing Kenneth Ofori-Atta told us he wasn't feeling well. Today he's a permanent resident.
I don't know how you
know the US too well.
No, but I'm saying that.
You didn't play the US.
If you want to have a constructive conversation, we'll have it. But the point is that you are bringing in Ken. We can talk about Ken. But I'm saying that be logical.
Just an example.
No, but that example was disruptive in the sense that you don't want to focus on the conversation.
The principle. I'm just testing.
Forget about the principle. The issue before us is this: that there's an effort to free Madam Sedinam Tamakloe. We now understand that she belongs to the category of animals in this farm who are more special than the others, more equal than others. So fine. I've shown you evidence, a pattern. So this whole thing that you are seeing from a certain paragraph, whatever, of 94 document, that one is part of the design to free her. Because you can nitpick on those things, but the substance of the matter is that our resources that she was supposed to be managing were dissipated.
By who?
You're asking by me? Was I the CEO?
The court's directive is that she has absolutely nothing to answer for.
If you believe that, let it be the case for our country. Because but the point is that I am shocked that you want to advance that conversation.
It's a court ruling.
It's not a court ruling. Yeah. Well, court rules and they can be overruled. Is that not the case?
They've not been overruled as of.
But the Attorney General has filed a position to appeal.
So
that
you believe in that process?
Which process?
The Attorney General's process, challenging that.
Challenging that, yeah. I mean,
you believe
in essence,
yeah.
That's what this whole thing. I've told you earlier.
Then it was not designed at all to free her.
No, you're not paying attention because you just want a certain outcome of this conversation. The point I'm telling you is that this whole thing appeal shouldn't have a reason, because if they filed the process as you said, and I heard that they filed it whilst we were in government. The question is that why did she not move on that at the time? Because she knew she doesn't have a case. But now her government has come, so she knows that somehow, okay, she is now more equal than the rest of us. So there will be some line in a 94-page document that frees her, and you will find it and bring it on your program and make that a subject of conversation rather than the enabling of corruption, which has become the order of the day since this government came to office. We have Sagleme.
Yeah.
The buildings are still there. Yeah. Shells. Yeah. But $200 million have been dissipated. And this government has issued a nolle prosequi to discontinue the matter. As a pattern. And all the people that have been freed and cleared. And comes her case, they arrange for her to come. She comes in, she won't go to jail, sits in the house. When people agitated, they sent her there. Only God knows which part of Insam she was staying. They were staying in some of the officers' bungalows or whatever. And then finally they bring her to court looking good, and then say she's acquitted and discharged.
She's looking good?
You understand? So you see a plan that is a government playing with our minds. And I'm telling you that these are dangerous stuff that you're doing. It's dangerous. Yes. It's dangerous. And you were inviting me to talk about Article 1911. When you introduced the matter, you were here when we were having the conversation about it regarding Untumi.
Richard,
but the judge, listen, the judge refused the referral, okay, to the Supreme Court for interpretation to determine whether what they were going to convict Untumi for was a crime to begin with, because it's not defined. And you have not advocated that. But today, you are advocating that on behalf of Madam Sedinam Tamakloe. So what is your motivation? You too, are you part of the animals that are more equal than others? What exactly is your motivation? I envisage that you and I will be here trying to fight for the public good. But somehow you are nitpicking. You are saying that a line somewhere in the bottom of some 94-page document calculated Richard, for a certain effect.
You just told me you were speaking as a Ghanaian.
Yes.
You are enjoined under the 1992 Constitution to uphold the principles, democratic principles.
Yeah.
And that should include fairness and justice. In fact, that's the baseline of our statecraft, right? Freedom and justice. Justice.
No, I'm not advocating for anybody's right to be abridged at all. Yeah. But I'm telling you...
So if a court order comes, I have no option as a journalist but to go...
What do you think would have happened?
Is that not prejudice?
No, listen, no.
That's prejudice.
It's a pattern. You are not following. There's a pattern.
You're creating that pattern.
Did I write a nolle prosequi that free the NDC people who are supposed to be tried? Did I write it?
I mean,
did I write it?
You didn't write that.
I didn't write it. So the pattern is being created by this government.
But this is not. This is not a nolle prosequi. Just to.
Of course, because she's been convicted, so they can't issue a nolle prosequi. The process they can use now is what they have used.
The records. This is not a nolle prosequi.
But I didn't say it was a nolle prosequi. No. Do you think that even this, if all the, I don't intend to pick on Honorable Collins Dowda anyway, but the point is that, do you think that if he was convicted before they came and they wanted to free him, don't you think they'll find this other, fancy...
You're being hypothetical.
Oh, I'm just telling you, because he's been freed on nolle prosequi. The case is not being continued. The resource that he was supposed to generate per that 200 million is not there for anybody to benefit from. But yes, he's walking free. The money is gone, okay? Yeah. But he's walking free. What did the government do? Write a nolle prosequi, clear him, okay? And then Sedinam Tamakloe, we can't write nolle prosequi, okay? So what we do, we don't take her to Insawam. Then people say we don't like it, take her to Insawam. Then she comes back, go to appeals court, one time cleared and acquitted.
Yes.
Why? Because they don't want
the incompetence of the prosecution.
Well, if that's what you choose to say.
This is the document
this is what you
from
are
the
saying.
court. And you see, all of these things, I'm not using my own words. If I have to be using my words, that's what's implied.
Well, because they have said it for you, you are using what they have said for you. That's okay. But I'm just saying, but the document, who says that is gospel? We are saying that the Attorney General will appeal it.
Yes. I
don't believe in the Attorney General's effort to be honest, but indeed, if it is, we'll follow the process and see.
Now you believe.
But I'm not telling. I'm sorry.
Now you believe in the Attorney General.
No, but it's a recourse, okay, for us to be able to get justice.
Yeah.
My fundamental test of this thing is that has the person taken our money? Where is the money? They took the money. The money is dissipated. And now you are telling me that there is a certain defect on a certain paper where somebody didn't underline something, somebody put a full stop, and so our money then suddenly is back in our pocket because somebody put a full stop on something, and they put that at the bottom of some 94-page document, and you are digging it out to say that is...
This carries the weight of the state.
You can call it what you want, but I say you can call it what...
The second harness
it is for me a travesty. Okay, and a reinforcement of the pattern that has been created, unfortunately, under His Excellency John Dramani Maham's administration,
Richard,
to make NDC people more equal under the law than everybody else.
Richard, let me be a bit more controversial. And so what? We allow Chairman Wontumi to be freed? Is that what you're saying?
I don't know where you say that. Wontumi, what is he convicted for? I believe fundamentally that Wontumi had not done anything for which he's convicted for.
He permitted illegal mining.
Huh?
He permitted illegal.
Okay, so what has happened to the person who actually did the mining?
But that's not my concern. You asked me about...
See the dishonesty.
No, but you asked me about...
You are asking me a question. I'm asking you a question. You don't want to answer yours.
You asked me about Wontumi.
We are asking...
You asked me about Chairman Wontumi specifically, and I'm telling you what he did.
And you say he facilitated...
illegal mining.
And then who did the illegal mining?
Who did the illegal mining? There's no court convicting any individual as of
But I'm saying that somebody did the illegal mining. Which you are saying
I don't know. I don't want to be liable to...
Don't be. But what are you talking about? Did you follow... As for that one...
Do you know anyone who engaged in illegal mining?
So as for this one, you didn't read the 94-page to see where the answer is.
But I'm not being unfair.
You are being very unfair. And I don't understand why you are doing that.
You know that's not the case. I'm saying to you that I know...
Hold on. You told me now, you just told me that Wontumi was jailed because he facilitated or allowed somebody to do illegal...
Convicted by a court, yes.
For...
Permitting illegal mining.
Permitting illegal mining. And I said, okay, I hear that.
Yeah.
Okay, that's what is on the charge sheet.
Yes, you're asking me who committed...
Yes, so the person...
Who,
you don't have to know the person.
Okay, right.
But the person who committed the illegal mining is for which reason he is being accused for facilitating. Yes. Where is the person?
Do you know the person?
You see the dishonesty?
No.
It doesn't look good on you.
If you know the person.
It doesn't look good on you.
If you know the
person who became the friend of Attorney General Dr. Dominic Ayine.
Oh, they're friends now?
Yes, they're friends.
Because
listen,
the judgment of the court
don't distract me. Don't distract me. Hold on. Don't distract me. He became friends with Dr. Dominic Ayine.
Oh, the one who
and my good brother, Justice Shrimsai.
Okay.
They convicted him to become their friends.
Oh, they're friends
now? collude with him to jail Wontumi for facilitating.
You're making serious claims.
Yes, of course, that's what happened. They made him a prosecution witness when he was the one who did the mining.
It's a crime now to make people witnesses in cases.
But you see, you make somebody a prosecution witness who observed and or was a witness.
Yes.
That has not committed principally the case, the crime that you want to prosecute. But here we are making somebody. Okay, a prosecution witness who actually is the one who committed the crime you are trying to prosecute. And you let that person go. Somebody kills somebody. The person who killed the person become your witness, okay, to prosecute and jail the person who gave him the key to go to the house. Is this sitting well with your logic? That man is walking about. So what is our business here? Are we trying to prosecute people who allow people to go to concessions to go and do reclamation, and they took it upon themselves to go and mine instead of mind the business of reclamation? They took the extra step, which they were not authorized. This is Wontumi's defense, that I asked him to do reclamation. I didn't ask him to mine. The man went there and took the liberty. He took the liberty to mine in addition to the primary task. And now you being Dr. Dominic Ayine,
asking a small-scale miner to do reclamation.
You being Dr. Dominic Ayine, You want to call that man who actually did the illegal mining, which all of us Ghanaians want to stop.
Yeah.
You let that man walk free, and the man will let him go on the concession. I don't understand in which world this makes sense.
I'm asking you a question. So
you blessed
a small-scale miner to do reclamation. Is what you're telling us?
Blessed.
Yes.
You're a fine guy.
Richie.
But you ought to be consistent.
I'm just
in fact, how many children do you have?
I don't have children.
Okay,
sorry.
you have children, and they are in your loins, listening to you right now and saying that what the hell is our father talking about?
What's this guy saying? Yeah.
What's that?
I would be old by then, so probably I'll have more reflections about.
Now, take your time. Purge yourself of these matters before you begin to break them, because you confuse them.
Oh goodness.
This thing with Untumi, it doesn't smell good. It is a travesty. Yeah. It is wrong. Because why? What we want, what President Mahama promised, is to fight Galamsey.
Okay.
He didn't say that I will come and fight people who did not allow ministers to sign documents. The concession, how Untumi got it, is not what is at issue. What is at issue is that he allowed somebody to go and do reclamation on his land. And you want to nitpick on the fact that the person is a small-scale miner. But I give you a principal instruction that go there and do reclamation. If you can't do it, you can tell me. Okay? But if you agree to go and do reclamation for me and you are stealing yourself to mine, you have committed an act. Now, right, if you had convicted the two of them and say for you, for going there and mining when you were supposed to go and do reclamation, you are going to be sentenced as well. And say, to me, you caused... Listen to me. You caused this thing because you allowed him to go there in the first place. You too will be sentenced, but not for Galamsey, but for facilitating the man to go to the concession. Then you can have some semblance of reasonableness to have a conversation. But the man who did the Galamsey is walking about, became Dr. Dominic Ayine's friend.
I see.
To prosecute the man who just didn't get signature. Yeah. How is that reasonable to you?
Richard, will you allow, and I'm just assuming without admitting...
Answer that question. How is that reasonable to you?
Okay, it's not reasonable.
Do you see reasonable?
It's not reasonable, but can I ask you a question? Would you allow a first-year medical student to carry out surgery on you as opposed to a surgeon?
I don't know where you're going with that.
Okay, but you know the obvious answer.
I don't know, because you are talking about small-scale mining.
Yeah, I'm talking about skills now. In the context of
okay, fine. Okay, so now proceed with your question. Well, I won't allow. Okay, so proceed. No, I won't allow.
Between a first-year medical student and a surgeon, who would you prefer?
I want somebody who is seasoned.
Seasoned?
Yes.
Would you allow a small-scale miner or someone who does mine support services, regulated under law in this country, to carry out reclamation on your concession? Which of them, as a responsible citizen, would you
Apples and oranges.
Okay.
Closing pits with equipment.
It's not just closing pits.
I have seen
this
this whole thing, what you need, I'm coming. Follow me. No, please. This is not rocket science. We have seen it.
Reclamation is not rocket science.
No.
You just fetch soil and pour into,
I'm saying that.
Into the holes
you think that a guy, was it him who sat in the heavy equipment and closed the thing? No. There are experts, operators.
He couldn't even afford the...
I'm saying, that's fine. So
he couldn't even afford it. Someone wants to be bought that for helping him buy that.
No, I don't know about that. But I'm just saying...
It's in the ruling. It's in the same judgment.
But that is not material. That is not
the 94-page judge.
That won't lead us to any conclusion, whether he bought it or not. I'm telling you that.
Yes.
The fact that you say he procured the services of somebody who is not an expert in reclamation, granted, is that offense equal to 20 years in jail?
The law gives a threshold, isn't it?
But no, what crime is that? That I am supposed to get you. Hold on. I'm supposed to get you, blessed, as opposed to somebody else to host a show.
Yes.
Okay?
Yes.
And out of my naivety, I get somebody else instead of you, the Don, right? Yeah. And that person comes to host the show, and the punishment comes. Is it the same as Is it the same as committing murder? Is it the same as committing Galamsey offense? No. You can't jail somebody because he has the indiscretion, exercise the discretion to procure the services of somebody else. So that indiscretion is tantamount to jailing him for 20 years. Don't you now follow the absurdity of what is happening to Untumi? Can't you see it now? So if all his crime is that he procured the services of somebody who's a small scale miner, okay, because he was naive about who he should get, then you jail him for 20 years. Where is it prescribed that when somebody fail to procure the services of an expert, then you jail them for 20 years? Where is that? Where is that?
The Mining Act.
Then the man who actually commits the mining is working free because he become your friend as a state.
The state didn't accuse Chairman Wontumi of conspiracy. Conspiracy takes two to tango. In this case, he was prosecuted for facilitating. There's a difference in it.
And I keep asking you the question.
Yes.
Permitted who?
I think we should ask
permitted who?
Permitted who? That's inconsequential. Because if you commit a crime...
I'm saying that your kids are listening to you in your loins and they're upset.
And they're so happy about how I'm working out key issues in the law.
So listen.
Yes.
So why
contravention? That's what you need to be liable.
Hold on.
When you
why did you put Wontumi in jail? Because he facilitated.
If someone trespasses your land, I'm sure you would want to get that person arrested, isn't it?
Where trespass in this case means what?
Yes. So the other
where's the trespass?
Liability.
Where's the trespass?
No, my point is
the man was not. The man did not trespass. Wontumi says go and do reclamation.
Yes. Okay. He can.
And the man listen. So now you see where we're saying that case, in my view, was inconclusive because the state had compromised the man, Mr. Henry Okun, to become its friend. Yes. In a certain collusion to jail Wontumi by all means. Yes, a collusion. Right. Because what it is a collusion. You see it clearly. Right. Because you are jailing somebody who, what he did merely was to show somebody a pathway to go here. And the person went there and killed somebody. Okay? And in our society, we frown on murder. Okay? So the two people, one showed the way and another went to commit the murder. Now you said that the person who showed the way, perhaps he didn't know what the person was going to do because he clearly told him go and do reclamation. And he went there, instead of doing reclamation, went to mine. And in our society, we frown on mining. So if you want to punish these two people, or if you want to punish anybody at all, in your wisdom, who should you punish?
Okay, Richard, we need to go.
Answer that question. Seconds. Who should you punish?
If you give someone your room to stay in, you'd go and check the room after the person is gone, isn't it? Anyway.
We have a long way to go. If this is...
We do have. If you have a message for the president, just speak to the president.
This kind of journalism would kill our democracy.
It won't.
It is.
You should trust me.
Because when you are reading 94, some page in a 94 document, and that to make that a substance...
10 seconds, talk to the president and leave me alone for now.
His Excellency John Dramani Mahama, the President of the Republic of Ghana, I love you. I respect you. You have accomplished much in your career. This that is happening under you now, you must not allow to continue. You are creating a certain pattern that in the future, others will mimic. They will mimic and say that the last time it was okay for some people to be above the law. And if we allow that to fester, this our country, this our democracy will not survive because others will do it and confidence in our judicial system would weaken, would wane, and we won't have a country.
All right.
That is not the country we want to build. Please,
so much.
The buck stops with you. Call your government and the people responsible for the justice system to order. Let everybody be equal before the law.
Any near free joy FM one near Air Channel 1 News. Anna so. Kasa near Paul Adum Watcheria. Woye good evening, Ghana. One so any Acquitted MP Bernard Bediako Bedu. Almost so at the echo shia on any almost so the coffin echo film from here. Nanny and ya na enya asem ketwa e honso so ye yanka say nua Paul Adom Watchere woni Richard Bernard Bedu enye obehwa e honso na ye jejeje a chese ensam no aye dendende ena de Sedinam Tamakloe wo de Sedinam Tamakloe or de ensam eba Sedinam Tamakloe wo de ensam beba Ghana jaya ye jawo ana say aye jejeja afa baabia ne yenkonkotie aye Sedinam Tamakloe won ne ho nsam a Paul Adom Watchere ene ye papa Bernard Bediako Bedu Acquitted MP NDC wo so ɛkɔkaa no wɔ ɛhɔ.
But there is something I want to also address. Paul even said it here, that it turned out that the notice of appeal was not filed. I heard him, I wrote it down.
In fact, Godfred Dame issued a statement and said it didn't come to his notice.
But that would be, I don't, you see, I'm careful. He's my senior at the bar. Really, Attorney General is saying that this document, Umar Sanda, read it. What date is on it?
I have on Eyewitness News yesterday.
What are we doing to this country?
So this is notice of appeal against a conviction and sentence filed by the first accused or appellant. It's dated. Okay, so case number CR 241 2019.
The filing stamp.
It's so the stamp is 9th May 2024
and all
at 2
that,
p.m.
Thank you. Yeah. I know, Sanda, all that the appellant needs to do is to do this. And Godfred Dame ought to know that the appellant need not do anything beyond this. It wasn't said. Was he expecting Sedinam to be holding it and taken to the office of the Attorney General?
Maybe they were not served.
But whom are you blaming? If it is the case, under your tenure, I filed this, assuming it's even the case. I don't even believe it, because if it didn't come to your attention, that's your setup. I mean, your own. I mean, I don't regulate it. But all I need to do as a defense lawyer is to file this to the court and take my copy. Pay the necessary fees if I have to. Even in criminal, this thing we don't normally pay. Do you understand? But if I file this, I'm done. How you get it is not my issue. So that cannot be the substantive point on which you build your point that the appeal did what and did what. What the court is saying is that there were defects on the charge, and you rightly put out that distance to Honorable. You see, the court referenced that point, that it is in the law, that if it has not caused any grave what do you call it? Miscarriage of justice. But in this case, it did.
Yes, that's what the judges said.
That's what the judges say. Whether we agree or not, that is why there is a different layer or a higher layer. That is what we should live it with. But to do, I mean, the sentiments and then the emotions and all that, it will not resolve the problem. It will not resolve the problem. This matter of what do you call it? The stay of execution. Yes, it's quite novel but let the courts, because if you read the common law, it's grounded there. But here it's novel. Let us hear the Court of Appeal on it. If they disagree with the Attorney General, whatever. If they don't, but for us to put out statements like the president or the government is, and people are attributing this to how she came in and then all that. Let us not put in a certain narrative and pursue it as though it is the case. The woman eventually, I told you, I sat here with you and I told you that, Sanda, you don't ask me where the woman is. Go to the prisons and go and find out. Do you remember on this show? Yeah. Did you do that? No. You didn't. So who was saying what? That the woman was in my house or in President Mohammed's house? What was the basis for that?
After your house there, that would be dangerous.
So in whose house was she? Doing what? So it turned out that the woman was serving it. But let us also not, for any stretch of imagination, assume that once you are convicted, you don't have any right anymore. Is that what we are trying to say? The woman is a citizen of the Republic and operates within our laws.
A political appointee.
Whatever. It could even be anybody. But she operates under the laws of the Republic, which laws are grounded in our statute. And the statute say that if a court convicts you, you can appeal. The woman appeals, it's not a pardon. The woman appeals and gets this decision that sets her free. The Attorney General says she will proceed to appeal. Let's leave it there. And then if you have any superior legal argument, as I sat here, what are the legal arguments people are making against this rather very sound decision of the justices of the Court of Appeal? If you have superior arguments, raise it. The Attorney General is late. We are all here. We may table all this. If you want to even offer professional advice to the Attorney General, you can go there. We all join you. But
or you can let the Attorney General hire
private
lawyers.
You can, yes. We all be happy to see you join them. The Attorney General can do that. But the Attorney General himself sees problem with it. The Attorney General, that's why he's appealing. So it means that he's convinced that there is something else he needs to do. So there is no issue. Let him proceed. Then the apex court will determine it. That shouldn't call for, because I'm saying that if you come to tell us that this one was a miscarriage of justice, is it because it's the Court of Appeal or what? Have you read the decision? If you read the decision, what are the legal arguments you are advancing to counter it? If not, then we should be careful, because most of your people are on trial now. Some of them are on trial. Some have been convicted, and they are going to the same Court of Appeal. If you are saying that it is the government, it is settings, the government found a way to, secure this conviction, do I then also say that in that case, then during your time, that this one cries 3 judges, then during your time, the High Court judge was also manipulated to give the conviction we have? Sandra, you understand me? Because if you say today that the 3 wise men were compromised, is it also the case that during your time, Godfrey Damming's time, he also compromised the High Court judge to come up with the decision we have? So what are we doing to ourselves? This thing will not take us anywhere. It will continue. People will be convicted. They would appeal. Once you use the established structure within the law, let the law take its course. But for anybody to believe that the executive has a hand in it, how is the executive going to have a hand in it? What do we get from it? What do we get from it?
Thank you.
That is my issue. So, Honorable, it is your own people that are politicizing it. Otherwise, we are here to look at the judgment. I have the judgment here. I wanted Paul to raise issues in the judgment. Unfortunately, today he doesn't want to. Page what? What did the court say that you disagree? What are the lawyers saying? The lawyers you interview, where have they raised issues with regards the legal arguments that has been?
Honorable, the reason why I didn't raise matters from the courts is that whilst you and other
you
NDC,
said we should leave the law.
You and I didn't say you should leave the law. You and NDC people have such a spirited defense of the Court of Appeal decision.
That's the decision.
Yes, it seems to contrast sharply with the Attorney General, the head of your legal situation.
Absolutely, that's right.
It seems that the Attorney General thinks that
he is the only appointee that is prescribed in the Constitution.
But it looks like the Attorney General looks at the judgment and will disagree with all of what you people are saying. And that's interesting for me.
That's good.
And that's why I don't want to raise anything in the judgment. Because these are all of you belong to one side. The Attorney General is the boss. The Attorney General's clear reaction is that I have disagree with this.
What is your opinion on it?
And then, no, how do I have an opinion when my opinion will be that
which page?
That's why my opinion will be political. My opinion will be political because
why is it political? All of you are not even a politician. I don't know what
all of you under Dominic Ayini are saying that the judgment is bad.
All of us under who?
All of you under Dominic Ayini are saying the judgment is bad.
You see why you so
Dominic Ayini, you are saying the judgment is good.
Have a decision.
Wait, all of you under Dominic Ayini.
You and the MPP also have a decision.
All of you on Dominic Ayini say the judgment is good.
And you and the MPP.
Dominic Ayini said the judgment is bad.
So I'm watching. So you and your MPP towards your position.
Look like I'm
what's your position? You and MPP.
The MPP is here to issue a statement on it.
But the people you interview who align with you, what did they say about the judgment?
They discuss the judgment.
What did they say? Page what? What does it say? Let us stop what you are doing.
But what is the point you are making?
It is important. Talk about the judgment.
If you have a view of the judgment,
philosophy.
No, if you have a view of the judgment, publish it.
Yes, we have.
You don't need anybody to publish it.
We are here now. We are here. We are discussing the judgment. Talk the judgment.
So you talk the judgment. So you want to talk.
But you don't.
Why are you inviting me to talk about it?
You don't talk philosophy.
But why are you inviting me to talk about the judgment?
But that is what we have.
Dominic Ayini disagrees with it. That's what I would say about it.
Yes. So
Dominic Ayini disagrees with it.
So we thank God
that the Attorney General disagrees with it.
We thank God.
All right.
Yes,
so you and your MPP,
the Attorney General, he's a leader of the bar.
This.
He disagrees with the judgment.
I'm saying that you should stop what you are doing.
Stop
because
doing
what we have is a judgment. If you have
a judgment with the Attorney General disagrees with,
you interview,
your Attorney General they disagree with it.
Have them look at this.
Why?
That is how
you want to be my producer. You want to be my producer.
Unfortunately, I don't have that power.
You want to be my producer.
Unfortunately, I don't have that power.
The people I interview, I should let them do it. Are you a producer of Good Evening Ghana?
This is the law.
You want to produce the program?
This is the position of the law.
You're a very intelligent man. Come and produce the program. We like you.
Unfortunately, I can't produce. Who am I?
Why you come and tell me that? Ask your guest. What question should I? You are not a producer of my program. Why we are happy for you to be a producer? Be a producer of the program and tell us what questions to ask the guests.
He said that the politics.
We should leave the law. Can we build this nation? This is the law. This is the law. Can we build this nation without the law? Can we build the nation without the law? No, tell me. Can we do that?
There is a foundation.
It's the foundation. In fact, it's the end.
But he also explains
that what?
That
what? Because look, the reason the law is important is that we have different shades of opinion. Yeah. So if your opinion is what should guide, and I have a contrary opinion, what happens? We are dealing with the law. Sedinam Tamakloe was convicted not based on your prejudice, your perception.
He said
was he? No. Was Sedinam not convicted based on the law?
Yeah, he was.
So why is the law an advanced form of it out, and you don't want to discuss it?
Paul's argument is that he is not learned, but the
no,
learned,
it doesn't matter.
the chief learned.
I didn't say that. I said that.
But that's a fact.
He's inviting me. He's inviting me to ask a certain line of questions of my guest.
No, you are here
based
today.
on the
I
law.
wanted to hear
But
you.
I'm saying
That's
that
why I
he's not
brought
my
this.
producer.
Yes, I've heard you on good evening, Ghana.
Yes,
that's yours. But today you are on big.
But if you want to be
and
a
the
producer,
big issue, the big issue. That's why I brought this big this thing, because the big issue. This is not good evening, Ghana. You called us to it. I mean, look at what the law is, which is the judgment. So all you said, I wanted to hear you look at the judgment page. What did the court say, rather than the philosophy or
the only way you can say that.
Science.
The only way you can say that if the host feels I didn't answer his questions, that's when you can say that.
No, that's
you
my
have to
view.
understand the context of program. If the host says I didn't answer his question, that's when you can say that.
But
you a co-panelist cannot say that you didn't answer the
I
question that was asked because I brought the law. No, you don't determine that we're on the same page. The host does. Yeah, please understand these things. No, please understand these things. The host does. Understand these things, boss.
Yes, but I have that right to also express my
understand these things.
You also stated your opinion. So
yes, honorable, please understand these things. I beg you, understand these things. If the host feels that a guest hasn't answered his questions, that's valid.
No,
but another guest cannot say that. Another guest cannot say that.
You come and talk about your wife here, you mind you.
No, fair enough.
No, it's true.
No,
I know you how you handle it. It's for the viewers to determine.
Let's leave it also.
So that's
viewers determine.
I've heard you. I came here and I know that what we have is a decision of the Court of Appeal.
And you stick to
it. As far as I'm concerned, Sedinam Tamakloe was convicted based on the law.
Very well.
So the foundation of all this discussion is law.
Okay.
So if you come and you want to discuss anything, it shouldn't be political science. It shouldn't be philosophy. It's the law, the judgment.
All right.
That is what we should be discussing.
Na ensemble nyina koswo no obi beka say attorney general yankasa ya attorney general Dominic Ayine Akorotenga asede na wo tie nsam no nyina koswo no say ai dede kwanamo ye asamu aba no me maye ma adwe se me ne me office ye be appeal case no na nu na ebinom ka say wo boa we de emfuturo ana obeto agu yani yenkwa ne yenkonkotie eye de ye pankasa ye papa Dominic Akorotenga Ayine wono so wo de baaye.
Thank you very much, Honorable Minister for Government Communications, the Honorable Felix of Ozukwachi. Ladies and gentlemen of the media and my fellow countrymen and women, as the Minister for Government Communications has indicated, I am here this afternoon to speak to the sovereign people of Ghana on the position of the government of His Excellency John Dramani Mahama on the final recommendations of the Constitution Review Committee. The recommendations of the CRC were carefully considered by Cabinet on 3 occasions, including the dedication of an entire weekend retreat presided over by His Excellency the President to deliberate on the recommendations of the committee. But as the Minister has indicated, before I delve into the substance of the recommendations and what government the position that government has taken, this morning the Court of Appeal issued a decision unanimously acquitting and discharging Sedinam Tamakloe, who was convicted of various offenses in absentia because, she was standing trial, and in the course of the trial, she sought permission to travel abroad for medical reasons and then remain in the United States for the rest of the trial. The trial court convicted her of the offenses charged, and then an appeal was filed by her lawyers in May 2024. I want this to be made abundantly clear that it was my predecessor who filed the appeal. However, coming into office, I reviewed what was filed, and I directed the Director of Public Prosecutions to file opposing the appeal, because we believe that the High Court judgment had merit. Now, with this judgment, I've also directed the Director of Public Prosecutions to file a notice of appeal and apply for stay of execution, meaning that if the stay is granted, the status quo will prevail until such a time that the Supreme Court has had time to review the appeal and then made a determination. So that is all that I can say for now. I have a soft copy of the judgment. I'm yet to peruse it and then come to a firm conclusion as to what will be our grounds of appeal. But I want to emphasize that I believe that the judgment of the High Court had merit, and that the United States District Court that extradited her to Ghana had a basis for making a determination that she was the proper subject for extradition. Now, there was a second question which I didn't get quite well. The person started talking about Sedinam Tamakloe, and I tried to motion to the person that, look, I have said it from the outset that this press conference is not about Sedinam Tamakloe. And also, as a lawyer of many years standing, I will not comment on a matter until I have read the judgment, and I have not read the judgment of the Court of Appeal. It has been sent to me, I have not read it. But I took the professional decision, and I stand by it in principle, that the appeal should be opposed. I inherited the docket, I inherited the extradition request, but government is a continuum. I reviewed the documents and I worked on them. So this is a principled stance, and it is a stance about accountability, okay, for this country. It's not about individuals. If it were about individuals, let me tell you, Sedina is my friend. She's my personal friend. It's not about personalities. It's about this country. And I'll take the appeal on to the Supreme Court. And to tie it on to your the question about face saving, if you look at me, I'm not the type of person who fears losing face. All right, I am not doing this because I want to save face for either myself or the President of the Republic. I'm doing it based upon professional considerations and also on the advice of the excellent men and women who work with me at the Attorney General's Department. So we'll review the judgment. You will see the grounds of appeal, and I'm sure at that point in time we can all have a discussion as to whether or not the appeal has any merit. And that is all that I will say for now.
Welcome to the Base USA, where we put Ghana first and empower the youth for a global impact.